Good morning, everybody. Thank you very much for taking the time out of your busy day to attend this seminar. It's great to see so many people signed up for this session. That may be a feature that the Procurement Act is coming very, very soon. By way of introduction, I head up our procurement and subsidy control team at VWV. I am going to co-host this session today along with one of my assistant solicitors, Isabel, who will come on later on. So this is the third in the series of Procurement Act webinars that we have been running. This one has particular focus on local authorities, but I know that we've got a wide range of attendees today from local government, education, from the wider sector bodies and from museums, and also from England and Wales, so everybody's very welcome. So after about 4 years, Procurement Act is due to come into force on the 28th of October, and there is now legislation in place to bring that into effect. Before I go into the session, I would just be very interested in taking a poll just to understand how ready you think your organisations are for the new Procurement Act. Okay. That's interesting that 54% say they are not ready. Well, hopefully this session will help in the journey to get ready. And I think probably our view listening to clients and contacts is that a lot of people feel that they're not quite ready. But summer has now finished, and of course we've still got 2 months to go to get ready for the Procurement Act, and there are some generous transitional provisions which we'll talk about in a minute. Just in terms of what's coming up, I am going to do an overview of the procurement framework in terms of legislation, because I think it's useful to understand that. And then the key features and what's changing in the first section. And then I'm going to turn to particular issues for local authorities. Now, as I mentioned earlier, we've run a series of these webinars. For earlier sessions covered particular issues for academies and higher education. So if you are in one of those sectors and you miss those earlier sessions, please drop me a line afterwards, and I'm very happy to send you the recording of those previous sessions, which covers particular issues for those sectors. We're then going to have a bit of light relief and run a quick quiz. And then we're going to have some tips on what you can do to get ready and checklists. There is an awful lot to get through, so apologies. We are going to start with the understanding that everybody's got a sort of basic knowledge of the current procurement regime. Otherwise, it would take a much longer session to get through, but hopefully I can help you get ready and provide you with some nuggets of information. So the public procurement framework. The main piece of legislation are the Procurement Act 2023 and the Procurement Regulations 2024. So one of the aims that you'll know about is the reforms is to simplify and consolidate the procurement legislation. So the Procurement Act itself is only 126 pages long, but it's a framework document, and the detail is all set out in the procurement regulations, for example, the details of the notice or the CPV codes. So in fact, you're looking at legislation which is, I think, just over about 250 pages long. So it's got a lot of detail, and there are lots of changes. So I would recommend always having a copy of the Procurement Act by your side. There have been 3 pieces of enabling legislation. Those are just to bring the Act into force. And the latest one is the one that has the go live date and the transitional provisions. I just want to talk a bit about the interpretation of the Procurement Act. Obviously, one of the points about the new reforms is to get away from the EU public procurement regime and to have our own domestic procurement rules. And so I think that's going to represent a shift in the way that the rules are interpreted. Under the Public Procurement Contracts Regulations 2015, obviously they were underpinned with the principles of fairness, transparency, and non-discrimination. Now we still see those concepts in the Procurement Act. Some of them are referred to as procurement objectives, and there's a requirement to have regard to those objectives, but it's not quite as strong as those principles that came across with the EU rules. So I think that's something that'd be interesting to see how that develops in the case law. The Cabinet Office and Welsh Government have also been producing a helpful suite of guidance documents, which on the next slide, please, Isabel, that's great, that we're finding very useful actually to read through. The guidance documents are intended to set out the key changes and the intentions of the legislators. We're finding that they've got some very helpful comments about how the procurement regime is going to work in practice. And of course, I should mention the National Procurement Policy Statement, which also needs to, we were talking about the objectives and principles earlier, need to have regard to the principles set out in the policy statement. Just by way of, before I start with the overview of the Act, just by way of general comment on the changes to the regime, certainly there is a lot more flexibility, and I think that procurement practitioners particularly are going to welcome that in terms of the ability to design your own procurement process. And there's much greater flexibility in terms of the selection criteria and award criteria that you can use. Obviously, that comes with transparency requirements, and there are also some big changes around, for example, the exclusion regime. My view is that there are lots of detailed changes which, if you're familiar with the existing regime and need to get to grips with the new regime, there are a lot of changes that can trip you up, and therefore it's going to take a while to get used to the new language, and particularly the rules about when you need to do standstill, when you don't need to do standstill, and when you need to do assessment summaries, and when you need to issue contract award notices. For me, there's a lot of changes around those procedures that need to everybody needs to keep on top of. We'll come back to evaluation later, but I think there's a big piece around making sure that you review your evaluation processes to make sure that they are robust and are going to stand up to the new regime. So going on to an overview of the Act, I've come up with a novel way of remembering the key changes through an A to Z. So if I run through these relatively quickly, so A is for a completely new procurement regime, which is for the England and Wales. So B is a behavioural change. So there's a lot of changes to transparency, which are going to require, I think, much more upfront work in thinking through how you're going to do it, and make sure that you then do what you say you're going to do. So I've mentioned C for consolidation, that the public contracts regulations is now consolidated with the concessions contract regulations and the utility regulations and defence and security rules as well. So debarment, the introduction of a debarment list is a big change, and that's coupled with having wider grounds for exclusion. So there's quite an important role when you're considering whether or not a supply needs to be excluded. And the concept of exclusion now extends to connected parties and explicitly to key subcontractors. So the Act introduces a competitive flexible procedure, so build your own flexible procedure to meet your requirements. We've talked about greater transparency. I think what's relevant, particularly for local authorities, are the rules on horizontal and vertical agreements. I'll touch on that in the next section. So we have for I interim order, there's now a provision under section 102 that talks about the if you get a challenge that is made to an award process, then obviously you get the automatic suspension of the procurement procedure, but there's any ability to go and ask the court for a number of interim orders. There are some tweaks and extensions to the grounds for direct award, and there is a requirement for a fairly detailed justification for direct award and an additional notice that goes with it. So on the next slide, we start with KPIs. Now, KPIs are good practice, but they are mandatory for contracts over £5 million, and there is a requirement now for contracts, large contracts, to contain at least 3 KPIs and to monitor performance against those KPIs. L for whole procurement life cycle. This is an important point that I wanted to make, that the Procurement Act has been extended so it applies to the whole procurement life cycle, starting with the requirement to issue pipeline notices, to plan a procurement, conduct your procurement process, but then goes on to contract management territory, covering payment of invoices, performance monitoring, and termination. N is for the National Procurement Policy Statement, which I have already mentioned, and there's a separate Welsh policy statement. Those of you attending from Wales. O is for open framework. So this is a tweak to the rules on frameworks, which allows frameworks to be in place for up to 8 years. It allows the framework to be reopened at certain stages to allow for re-evaluation of existing suppliers and the potential to introduce new suppliers onto the framework. C is for the new central digital platform, which I understand is going to be the enhanced find a tender. We certainly haven't had much information about that, so we're looking forward to the introduction on the guidance note around the digital platform. Q is a bit of a cheat because I was struggling to come up with a name for Q, but we've stuck with selection questionnaire. I think probably the selection questionnaire won't exist under the new world, but that's something that is still to be confirmed. The selection criteria are now referred to as conditions of participation, and there is a possibility to ask for additional questions that you would normally put in the selection questionnaire, but my understanding is all going to be using the central digital platform. R is for remedies. There are some detailed, although the remedies haven't changed substantially, there's a lot of detail. For example, changes to the calculation of the standstill period in the remedy sections you need to be aware of. Assessment summaries are they're part of the new requirements that were previously the standstill period. The requirement for an assessment summary is effectively to give successful suppliers and unsuccessful suppliers a version of the evaluation matrix so that they can understand where they lost points or where they were strong, and to understand the scoring with reference to their particular tender. The idea is to make sure that there isn't, what we would often see with standstill letters is that the standstill letter sometimes didn't have much bearing to the evaluation sheets. And that's to stop that happening. But I think there are some tips that need to be taken into account in preparing his summaries to get the level of disclosure right. So T is for below threshold contracts. There are some new rules that apply to below threshold contracts. Procurement review unit is a transformation of the existing procurement review unit, and will have much wider ambit to investigate practices under the new Procurement Act. And dynamic markets is the replacement for the dynamic purchasing systems. They're going to effectively be the qualification system, which is a concept that's been brought across from the utilities regime. Okay, so I mentioned before that the transitional provisions are quite generous. So the good news is that the PCR will continue to apply to procurements commenced or awarded prior to the 28th of October. So what has happened is that there has been a narrowing of the definition of when is a procurement commenced. So a procurement is commenced if you've already issued a contract notice, but if you have issued a PIN notice, you can't rely on that unless it was issued before the 26th of May 2023. If you are going down a direct award route, you have to issue a voluntary transparency notice now in order to commence procurement under the existing rules. Or if you're using a negotiated procedure, you need to have notified the supplier of an intention to negotiate. Now, for those people that want to use frameworks and the dynamic purchasing systems, the good news is that there is a lot of flex around these. And I think in practice, a lot of people are going to be relying on calling off contracts under frameworks and DPS in the near future while they see how the Procurement Act gets bedded in and get completely ready. So if you have a framework or DPS in force, then they will run for the period of the duration of those tools, and any call-offs made under it will continue to be governed by the PCR. The one exception to that is for DPS, so that there's a cut-off date, which is either the earlier of when they're due to expire or 4 years. So the latest a DPS can run to is the 27th of October 2028. If you're going to modify a contract, you can do that provided you use the existing rules under 72 under the PCR, because the rules under the new regime are slightly different. But there are also some tweaks to watch out for. So, for example, the requirement to publish information about prompt payment starts from the 28th of October. And I'll come and talk about pipeline notices in the next section. So going on down to issues for local authority. I appreciate that many of you will feel that it's tough now in local government with all the pressure on costs. And I think this is probably going to be the biggest challenge. So we've seen the number of notices that need to be published in relation to a procurement rise to, I think the maximum was 26 we counted, which is a significant increase in the number of notices. And there's a lot of detail that needs to go into the notices, and obviously they need to be published. I talked about pipeline notices. So very often you might have been in the practice of issuing regular pipeline notices, but this is now a legal requirement. And where you are issuing procurements, anticipated procurements over the next 12 months, and the value is anticipated to be over 100 million, then you have to issue a pipeline notice. Now, there's an odd way in which it's been worded. So the 100 million is triggered over a 12-month period, and you have to set out details of contracts over 2 million as part of that pipeline notice, but those are contracts looking forward over 18 months. Now, the good news is that the first notice doesn't have to be issued until 26th of May 2025, and that's because the way for calculating the years is based on the financial year April through to the end of March. Contract management provisions, I mentioned about the Procurement Act extending into the whole contract life cycle. So we have got KPIs for contracts over 5 million, got performance notices, and there's quite a lot of stuff there. So I just have picked out a number of the special regimes under the Procurement Act, which I thought are worth mentioning, because I think these will be particularly relevant for local authorities. So there are a number of circumstances when you, as contracting authorities, can reserve contracts to certain suppliers. So I've referred to the TECL exemption, which is the vertical and horizontal exemption, which allows government organisations to contract with one another outside the scope of the procurement rules, providing certain conditions are met. Now, the concepts of the TECL exemptions have been carried over from the EU procurement rules. And so you have this provision that says that an organisation must, if it's being set up as a subsidiary company, must carry out at least 80% of the activity for the parent company. And there's been a lot of discussion about how you calculate the 80-20 rule. And my understanding was that there was guidance supposed to be issued about the methods of calculation. I'm not sure whether it's intended to come under the guidance note, which is labelled intra-UK procurement, or whether this is going to be separate guidance that's been issued, but I think that's something to watch out for. The other reserving contracts is it's in the Procurement Act, but it relates to a below threshold procurement. So previously under PPN 1120, there was the possibility for central government and other wider public sector bodies to reserve procurements either to suppliers by a particular location or to particular suppliers, for example, SMEs or voluntary community enterprises. Now, that wasn't available to local authorities because of Section 17 of the Local Government Act, but that has now been disapplied under the Procurement Act. So that means that PPN is now applicable and available to local authorities. There's also a provision for local authorities to provide that suppliers can reserve the right for tenders to be made available to public sector mutuals only. So just a word about the provider selection regime 2023, because this is in force and relates to local authorities carrying out healthcare services. So where you're carrying out healthcare services, and those most likely ones that we've identified are community health services or rehabilitation services, then the provider selection regime is likely to apply instead of the Procurement Act. Now, the provider selection regime was introduced last year and is a separate procurement regime for healthcare services, and it's a much lighter touch regime and has got quite a different setup in terms. There's a presumption that you can continue to use an existing provider in certain circumstances. So that's just something to watch out for. So in terms of frameworks, I wanted to highlight that because, as mentioned, I think that's going to be a common tool going forward. We've talked about open frameworks, but I just wanted to mention a point about frameworks which I've recently picked up, which is that previously there was no requirement to issue a standstill letter for call-off contracts. Now that hasn't changed, but what has changed is the requirement when you are calling off a contract to issue a contract award notice. So it's an intention that publishing an intention that you are intending to award under a call-off contract, but you don't have to have a standstill period that accompanies it. It's voluntary. But that's an example of one of the little tweaks that is in the Procurement Act and is easy to trip up on. Light touch contracts. There are a lot of areas where local authorities are going to be procuring, which are light touch contracts, and I am going to hand over to Isabel, who's going to talk about some of the key differences between the light touch regime now and under the new Act, as well as talking about the noticing regime.
Thanks, Stephanie. Hi, everyone. I'm Isabel, so I'm a solicitor in the procurement team at VWV, and I'm here to talk to you about what I'm sure is everyone's favourite topic by now, notices. So, one of the key aims of the new Procurement Act is to improve transparency throughout the whole life cycle of a procurement. So, unfortunately, more transparency also means more notices. So what we've done here is split out a fully covered procurement into the main 4 stages. So you can sort of see what notices you might need to consider for each stage of a procurement. So if we start at the plan stage, the pipeline notice Stephanie mentioned in a previous slide, sorry. So this will only apply if you are going to be spending more than 100 million on public contracts within the coming financial year. So that's quite a high value, but it is definitely something to keep in mind. A planned procurement notice, this is actually optional. So this is similar to the PIN, which is what we have under the current regime. This basically just informs the market that you intend to publish a tender notice in the future. Similarly, the preliminary market engagement notice is quite self-explanatory. Basically, it just needs to be published if you intend to carry out market engagement or you've already carried out market engagement. So the actual procure stage, the tender notice. So this is a renaming of the current contract notice. So there's a couple of terminology changes within this new act, which might take a while to get to grips with, but this is basically the notice that you post to actually commence a procurement. Transparency notice, this is required now if you intend on making a direct award. So the contract award stage, the contract award notice, like Stephanie said, this is the one that sets out the authority's intention to actually enter into a contract. So this is an important notice to remember and to get to grips with, because this is the one that actually triggers standstill period. Procurement termination notice. So this is a new notice, and this is a change from the current rules. This is required now if you decide to abandon a procurement once it's already started. So that's definitely one to keep in mind, because I think that does happen quite a lot. You start a procurement and then realize that it's probably not a goer, so abandon it. You now need to publish this notice. A contract details notice. So this needs to be published, and this will basically contain details on the final contract. So things like the final value, the duration. So this needs to be published for a standard fully covered tender procurement. This needs to be published within 30 days of contract execution. Now, if it's a light touch contract, that timeline is actually extended to 120 days. So it's quite a big change. And one point to make here is that if the contract is over £5 million, then you also are required to publish a redacted copy of the contract. Again, to help improve transparency. Finally, contract performance. So there's a couple of notices in here which are only applicable to certain contracts. So the contract change notice, this is not applicable to light touch contracts. So you need to publish this notice if you are making a modification to the contract. Similar with the contract performance notice, this also doesn't apply to light touch contracts, but this notice is used to basically provide an assessment of the supplier's compliance with the KPIs if they've been set. Contract termination notice. So this is different to the procurement termination notice. It basically needs to be published within 30 days of a contract being terminated. And finally, the payment compliance notice. This is used to publish details on the contracting authority's performance against those 30-day implied payment terms. So as you can see, there are quite a few notices, and they obviously cover the whole life cycle, and some of them are going to require quite a lot of forethought. So especially like the pipeline notice, you're going to have to get those notices in line before you even start the procurement. So it's an important thing to try and get used to and get to grips with. So light touch regime. So just as a general point, the way that the light touch regime is handled is slightly different than in the PCR, which is the current regime. So under the Procurement Act, it's now done by exception only. So rather than having a specific separate regime, it's done by exception within specific clauses. We go through the main changes of the light touch regime in the next slide, but what we've done here is just gone through and picked out a couple of services which we think might be relevant for local authorities. But rather helpfully, actually, the procurement regulations actually set out a full CPV list of all of the services which are classed as light touch. So if you ever need to just double check or clarify whether a service is light touch, you can find that in Schedule 1 of the procurement regulations. Okay, so as we said, there are quite a few changes to the light touch regime and how it will work. So process, just more generally, the process of a light touch contract still has to comply with the procurement objectives. So these are set out in Section 12 of the Act, but include things like delivering value for money or maximising public benefit. So even though it's a light touch contract, it still needs to comply with those. So that's an important point. Obviously, because it's light touch, it does benefit from lighter regulation. So there is more flexibility to sort of decide the process and the evaluation criteria. But the important point to make here is that it is, of course, still subject to transparency. So what that means is that basically it needs to be clearly set out and clearly outlined at the beginning in the tender documents. Another point is that there's also no requirement on time limits for light touch contracts. So for a standard contract, there are certain time limits between, say, the tender being published and then the suppliers having to submit their responses. These don't apply for light touch contracts. So section 51 of the Act deals with standstill. So this is probably the biggest change to the light touch regime that you'll have to get on board with. So there's basically no longer a requirement to hold a standstill period prior to the award of a light touch contract. So obviously this is very different to what we have under the PTR, but it is still encouraged, and we think that we probably will see quite a few people still using this voluntary standstill, just because it reduces the risk of the contract being set aside. So it's quite a helpful tool to still incorporate. Section 52 deals with KPIs. So we mentioned these briefly in our previous slides, but these are the requirement to set and report on these KPIs isn't required for light touch contracts. Again, these are still encouraged because it's quite a helpful tool to try and monitor contractual performance. So it might still be something you want to consider. Exclusions and debarment. So just generally, this is quite a big change to the rules anyway. Obviously, the introduction of the public debarment list is going to be quite a big change. So previously, the application of exclusion grounds was not mandated, but it was encouraged for light touch contracts. This has changed, and now the exclusions and debarment will apply to light touch contracts. So again, that's something that you'll have to consider sort of right at the beginning of your tender, because you'll need to check that any suppliers aren't on this debarment list. 74 deals with modifying a public contract. So as we said, light touch contracts benefit from having greater flexibility. So there aren't any restrictions on modifying a light touch contract. So even if the modification means it's substantial, there aren't any restrictions. And as a bonus, you also don't have to publish a contract change notice. So that's one less notice for you to consider. Finally, the conflicts assessment. So this is set out in section 83. So even if it is a light touch contract, before publishing a tender, the authority has to prepare a conflicts assessment. So this will basically set out whether they've identified any conflicts or any potential conflicts and what steps they're going to take to mitigate this conflict. So as you can see, there are obviously some big changes. So the standstill, that's quite a major change. But there are also some really small tweaks. Like Stephanie mentioned, there are some small points which could be quite easy to trip over. So if you are an authority that deals quite a lot with light touch contracts, there is a guidance note that's been published, which is really helpful actually. So it might be worth just taking a look at that, trying to get to grips with all these small changes before it goes live. So now to see if you've been listening. So you've heard me chat on about notices. Are you going to be able to spot the fake notice? So we've got tender notice, planned procurement notice, debarment notice, and contract performance notice. Oh, there's a clear winner so far, which is good news. Okay, so 88% of you have been listening, which is good. Yeah, so the fake notice is the debarment notice. So there isn't a debarment notice, but there is a debarment list. So I have also mentioned this. So what will ineffectiveness now be called under the Procurement Act? So like I said, there's quite a few changes in terminology, which we're going to have to just get used to using. And this is one of them. Again, looks like most people have been listening. So yeah, so the correct answer there is set aside. So ineffectiveness will now become set aside. So that's just a small change that we're just going to have to get used to using. And finally, how is standstill triggered under the Procurement Act? So is it by an assessment summary and contract award notice, a debrief letter and award decision notice, or a standstill letter and contract decision notice? Again, this is a bit of terminology. Okay, this is a bit more evenly split. So 64% of you were correct. So standstill will now be triggered by the assessment summary and contract award notice. So 33% of you still say the standstill letter and contract decision notice. So the standstill letter, the term of the standstill letter will now become redundant under the Procurement Act. It will now be referred to as an assessment summary and contract award notice. So just a point to make on the contract award notice, the day that this is sent out to suppliers, that will actually class as day one of the standstill. So that's something to remember. Okay, now I'll pass you back over to Stephanie, who is going to let you know what you can do to get ready.
Thanks very much, Isabel. So just some helpful tips in terms of what you can do to get ready. Obviously, the first point is to familiarize yourself and your team with the new procurement regime, and there are lots of resources available from the Cabinet Office to help with that. And some of you, no doubt, will have been able to benefit from the training from Cabinet Office. I think also a point that is really important to make is to engage with clients and stakeholders in your organization, because it may be that you have a good understanding of the changes, but actually it's making sure that everybody within the organization understands the impacts of the changes. So, for example, finance will need to be able to report on prompt payment. Contract management will need to have input into setting KPIs and then monitoring performance. Procurement and legal are going to have to work really closely together to make sure that all the policies and procedures are joined up. And then there is also making sure that suppliers are understanding the changes. I think when the central digital platform goes live, that there's going to be there's going to take suppliers quite a lot of time to get to grips with the new central digital platform and to upload all of their information onto it. And then, of course, there's reviewing and updating all your procurement policies and procedures, templates, and terms and conditions to make sure that they reflect not only the change in language, but also the changes that are happening in terms of changes to competitive flexible procedure, in terms of conditions of participation, in terms of standstill period. There's quite a lot to think about there. And I put pipeline planning in the list because it's worth thinking about, if you haven't already done so, what about your up and coming contracts and which ones are going to be procured under which regime. So I put together on the next slide a checklist which I hope will be useful for you. So I think these are in no particular order, but these are things that you're going to need to look at to make sure that they are up to date. So your procurement strategy and policy is going to be a key document which sets out how you are going to plan procurement for the next few years, and will need to be updated to reflect the changes. And then very importantly, the organisation's contract procedural rules and the financial procedural rules, which set out all of the policies and processes which are relevant to the procurement function. I mentioned procurement templates, in particular the ITT, to make sure that it reflects the way that you want to carry out your procurements going forward, and the changes to language, and for example talk about the new grounds for exclusion. Standard terms and conditions, I think it's easy to forget that one, but they obviously form part of the TEND documentation, and there are going to be some knock-on consequences for those. For me, I've mentioned it, but I think the assessment summary template and providing guidance as to how you complete this assessment summary template is going to be key. And what you need to do when you are providing the assessment summary template of successful supplier to the unsuccessful suppliers, there's going to need to be a certain amount of redaction that is taking place to make sure that you're not providing unsuccessful suppliers with commercially sensitive information. And actually, that's a point that also needs to be reflected into your procurement templates, which is there needs to be a section setting out information that is going to be provided to suppliers, and asking for suppliers to set out what information is commercially sensitive. And then a conflict of interest assessment form. This is very often you might have already had some process for managing conflict of interest, but this is a mandatory requirement now, and again something I think is not always picked up, to include the conflict of interest assessment form as part of your procedures. Now, I'm conscious that we've gone through a lot and we probably want to have time for questions, so I'm going to whiz through this slide and we can go on to questions. So we've got a specialist team at PWV, and we're very happy to support with templates, policies and procedures if you just find that you're running out of time or just want a bit of additional help. We're also running a Procurement Act helpline to provide sort of a second opinion and support while you're going through the first 3 months of the new Act. We've also got a load of free resources available, so do sign up to our mailing list. I'll put a link in the slides which are going to be circulated. So we've got podcasts, we've got FAQs, we've got blogs, and we're sending those out on a fairly regular basis. So if happy to take questions for the next few minutes. And I just wanted to make a clarification to one of the points I made earlier in relation to the right to reserve particular suppliers below threshold contracts. Thank you to Kieran for clarifying this point. There is a provision in the Procurement Act which talks about the disapplication of Section 17 of the Local Government Act, so that contracting authorities can decide to rely on PPN. But I understand that there's been a slight tweak, which means that the wording is that the regulations may disapply, and that actually at the moment there aren't the regulations in place, so that we're still waiting for that change to be made. When you've got any queries about that, please drop me a line afterwards.
So we don't have any questions at the moment, but if anyone wants to send some in.
If you have any questions that arise subsequently to the session, please don't hesitate to drop either Isabel or I a line.
So we've had one about below threshold contracts. Seeking clarification regarding below threshold contracts. Are quotes required to be issued through CDP, or can they continue to be issued through our e-tendering platform? That might be a bit tricky for us
I think
to
that's a
answer.
very good question. We haven't had much visibility about I mean, my understanding is that the CDP, the e-tendering platform, is going to work with the CDP. Maybe one that needs a bit of clarification when we get the guidance from CDP. Unless anybody knows the answer to that one, put it in the chat.